One of the most boring risks that people don't think about enough is probably the documentation. When a prosecutor or a regulator come in and they have started an investigation and they want to look at something, you want to serve up the answers to them in a way that's easily digestible. You don't want them to have to go hunting for it. You don't want them wondering, well, does this company have a policy against money laundering, for instance?
Welcome back to Fintech Layer Cake. On today's episode, I chat with Laurel Loomis Rimon, a partner at the law firm Jenner & Block. Laurel co-chairs the fintech and crypto assets practice and founded their payments practice.
On the DOJ side, what I would say, generally when it comes to financial crimes, it's almost never the case that the company truly is the target from the beginning. What happens is it's sort of reverse engineered. Fraud investigations, child sex abuse material investigations, terrorist financing, narco trafficking, whatever it may be, they're conducting those investigations. And at a certain point, what they see is that funds keep going to a particular company.
How does a regulator or prosecutor actually assess good faith? What are some of the top things?
Staffing is always key. It doesn't necessarily mean that you have to have huge numbers, but if you don't have the right people in the right places, you've got a problem.
Welcome back to Fintech Layer Cake, where we uncover secret recipes and practical insights from fintech leaders and experts. I'm your host, Reggie Young, Chief of Staff at Lithic. On today's episode, I chat with Laurel Loomis Rimon, a partner at the law firm Jenner & Block. Laurel co-chairs the fintech and crypto assets practice and founded their payments practice. She brings experience as a former DOJ prosecutor, which included the first ever digital currency company prosecution, as well as experience at the CFPB as an assistant deputy enforcement director. We cover Laurel's lessons on how enforcement and prosecution in fintech works in practice, what practically exposes fintechs and banks to enforcement or criminal prosecution, her thoughts on how banks and fintechs can navigate the pushback on debanking, and much more. Fintech Layer Cake is powered by the card issuing platform Lithic. We provide financial infrastructure that enables teams to build better payments products for consumers and businesses. Nothing in this podcast should be construed as legal or financial advice. If you enjoy Fintech Layer Cake, please give it a review on Apple, Spotify, or wherever you listen. Welcome to the podcast. Excited for a conversation today. And one of the places I'd love to start is something you mentioned when you and I last chatted, and I immediately latched onto it. And I was like, that's the topic we got to cover, which is that you prosecuted the first digital currency company, E-gold. I believe that was in the late 2000s, if I'm remembering correctly. I would love to hear about that experience. What did prosecutors understand about digital currency at the time? How did that case evolve? It's kind of around the time that Bitcoin was being created, but not really in anybody's zeitgeist other than the folks who were maybe working on it. So it's a particularly interesting time for digital currency. So yeah, I would love to hear about that experience.
Yeah, thanks, Reggie, and happy to talk to you. Just to set the stage a little bit on that. So I was an AUSA in the U.S. Attorney's Office in D.C. at the time. I was pregnant with what is now my 20-year-old. It was 2005 and 2006. And I had sort of a reputation in the office for taking on some of those sort of more difficult, non-obvious financial cases at the time. And so when my supervisor walked in and brought me this case, it was something that folks didn't really understand, and I was happy to dig into it. But, obviously this was, as you mentioned, sort of maybe when crypto was sort of a glint in the eye. So this was not a blockchain-based digital currency case, but in every other respect, it was the same as the cases that I deal with now and today and have dealt with for years. So it was a case involving, essentially a private digital ledger and digital currency called E-gold that was being used to buy and sell various things online at the time. And the case had come into being because the Secret Service had a very large credit card fraud investigation that they had been doing for many years. And many of the transactions that they were investigating led back to the E-gold platform. So got involved, and that investigation ended up being a multi-year investigation involving multiple companies, several individuals, and some very large forfeitures in the end.
What was the sort of hook? I think crypto prosecution nowadays is a sort of well-trodden path, but what were the sort of legal hooks to try and, prosecute a digital currency company at that time?
Yeah, I mean, these days, if you're in the space, you've heard of and are familiar with, the term money transmitting and probably the criminal statute 18 USC 1960, which, makes it illegal to operate an unlicensed money transmitting business where a license is required. But that was certainly something I was not familiar with at the time. It really wasn't something, sort of non-bank financial firms were not big at that time. So it wasn't something that was really focused. But obviously, money laundering itself, so if you're conducting transactions involving the proceeds of crime or to promote crime, then that is generally money laundering. So the case involved both money laundering, potential money laundering crimes and these potential 1960 unlicensed money transmitting crimes. And the money transmitting piece was really sort of novel. Folks will remember that in 2013, FinCEN came out with the first guidance sort of clarifying that digital currency activities constitutes money transmitting under certain circumstances. But this was prior to that. And I would say probably the foundation for that, which came later, was the work that we did at the time to take the position, which we did in multiple indictments and ultimately was upheld, at the district court level, to charge money transmitting violations related to digital currency activities.
Interesting. Yeah, so such a money transmission is now such a baseline consideration for anyone in
Right.
crypto, any product counsel touching crypto. Interesting to hear about that being sort of a novel approach at the time. You've also spent time as Assistant Deputy Enforcement Director of the CFPB, so I think both the prosecution side and that enforcement side. I'd love to hear what actually makes a company a target. What puts a target on a company's back? I'm excited for this episode because I've spent most of my career, my legal career, I was at law firms for a little bit, but I've been mostly in-house. And there's always this sort of like practical risk question of like, inevitably you hit gray areas, undefined areas. And I'd love to hear what makes a company go from on the radar of the CFPB to, oh, we're going to open an enforcement action or, for prosecution side, opening an investigation.
Yeah, I always find it somewhat ironic since I've been in private practice, which has been about 8.5 years now, that I tend to be, less conservative on these questions, I think, than folks who've been in-house or in law firms. I guess having been on the government side as long as I was, I have a sense that it really takes something significant to become a target. But I also do want to differentiate between being sort of a focus of something like the CFPB, and obviously the CFPB these days is a little different than it was when I was there at the early days, but sort of a financial regulator versus the Department of Justice on the criminal side, I would consider a little bit different. So on the DOJ side, what I would say, generally when it comes to financial crimes or financial cases, it's almost never the case that the company truly is the target from the beginning. What happens is it's sort of reverse engineered. You have agents out there that are conducting their regular types of cases, fraud, investigations. Fraud investigations might be child sex abuse material investigations, terrorist financing, narco trafficking, whatever it may be. They're conducting those investigations. And at a certain point, what they see is that funds keep going to a particular company. And then maybe you have multiple investigations where those funds keep, going again to the same company. And at some point, an investigation gets open on the company itself. So that I consider sort of a little bit of a different situation. And it's why when I talk to my clients, keep an eye sort of on the market, make sure that you don't become the platform of choice for illicit actors, because that's how you get in trouble on the criminal side. When you're talking about the CFPB or a financial regulator, they are more likely looking at, sort of who are the financial services entities in the marketplace that are having the biggest impact. With regard to the CFPB, what I would always say is, the staff at the CFPB and at the AG's office and the, state financial regulators, they are consumers themselves. They're partners, they're grandparents, their kids, everybody is a consumer. And so it's not very hard for them to sort of just look up and sort of see what are the companies that are having an impact on my daily life and what should we look at. So it's a little bit different in either place. And it's something definitely to sort of keep in mind as you're thinking about your risks, and you're building your products.
Yeah, I love it. There's a apocryphal story in the sort of credit card regulation space of how, some senators' kids were getting the, credit cards when they were 2 years old in the mail. That kind of led to some of the initial credit card regulations and frameworks. So similar, good illustration of that. That concept of like, oh, it's the regulators and the policymakers. They're also, I think about this from sort of, keeping a close eye on customer complaints, because that, complaints can end up being submitted directly to regulators. And obviously you want to be customer centric generally. So it's a good barometer for that. But also good to remember that sometimes the prosecutors and the policymakers are some of your customers too.
Absolutely. I mean, I literally had a CFPB case that I was representing a client, and the primary complainant was the son of the CFPB lawyer.
Interesting. Funny.
Yeah.
What do you think that fintech operators worry too much about, and what risks don't they worry about enough?
Yeah, I mean, it kind of goes with, what I was saying about I tend to be less risk averse than some just because of my background. But I think what they probably worry about too much is technical violations. There's enough out there for regulators and prosecutors that they're not really looking for technical violations. They've got other things to do. And, in terms of risks, they don't think about enough, probably a much longer list there. But, one of the most boring risks that people don't think about enough is probably the documentation, which everybody talks about. But the way I think about it is you don't want a prosecutor or a regulator substituting their own judgment or idea for yours. So when they come in and they have started an investigation and they want to look at something, you want to serve up the answers to them in a way that's easily digestible. You don't want them to have to go hunting for it. You don't want them wondering, well, does this company have a policy against money laundering, for instance, to take the most
Hmm.
obvious example? You want that to be easy for them to see. So documentation is, sort of the bane of everybody's existence in this world. But at the same time, that's how I think about it. And if I think about it that way, it helps me prioritize what are the pieces of documentation that you want to have, most accessible. And then maybe the other thing I would say that fintechs don't think about enough, and I know they think about it a lot, is user experience from a sort of regulatory point of view. Everybody, that I work with is very concerned about getting things right, making sure all the elements of the way a platform is set up, meet various rules and regulations. But oftentimes that's looked at as sort of a piece by piece basis. And you put it together, and that may or may not come through what the user experience is in terms of how information is conveyed. So I know that, particularly on the financial regulatory front, regulators look at that and say, well, you may have meant to include all those elements, but when the user, my grandma comes to use it, it's not so obvious to her.
Yeah, that sort of end customer product thinking is very important. I think quite rare among lawyers. So I love that you're talking about it. In the past, you said that genuine good faith compliance efforts are what matter when something goes wrong. How does a regulator or prosecutor actually assess good faith? Is it, document? We were just talking about policies. Like, okay, do they have an AML policy? That seems pretty table stakes to me. But other sort of things that a regulator or prosecutor would look at to assess good faith, like remediation plans in progress or having a qualified BSA officer? What are some of the top things?
Yeah, I mean, that's a good list to start with. I'm a bit of a broken record on this point. I mean, staffing is always key. And in the age of AI, that's a really interesting question. What does that mean? It doesn't necessarily mean that you have to have, huge numbers, but do you have enough people in the right places with the right qualifications? Is it a genuine compliance effort? The government, I think, understands shoestring operations. They understand you have to have some revenue to build, but if you don't have the right people in the right places, even if it's running the AI tools, then you've got a problem. A couple other things I think about, one that's maybe not always as clear, to companies, I think, is the role of a internal reporting or whistleblower program. That can go a really long way to showing good faith. Of course, you have to have, meaningful processes around that. It can't be a dead end. You have to be able to show sort of how those concerns are handled and that they're handled appropriately and all of that. But I think that's a really strong way to show good faith. And then just on a very high sort of overarching level, I think what certainly at DOJ and probably regulators also look at is the profit, outsizing the investment? Is the investment in compliance, taking a bite out of the quick buck? And I know a lot of the platforms that I work with are not, it takes years to get positive space. But the expectation is that the revenue is going to support the compliance build out at the same time it's supporting the increase in, transactional activity.
Yeah, there's a good example going around right now of a sponsor bank that recently got a consent order, and you kind of look at their explosive growth, hundreds of percents of growth without adequate investment to match the growth needs. I talk about this with, when you talk to a bank, they're focused on risk. When you talk to a fintech startup, they're focused on hope and opportunity. And you kind of have to like speak both languages, and you have to come to the bank and say, here's all the risk controls. And like, we're not going to grow too aggressively because we want to make sure we have guardrails and then we don't like blow everybody up in this. So it's a funny two-step dance.
It really is. And it's not new, and it seems kind of obvious. It's also really easy for me to say, I'm not the business trying to grow, so, but it's a real red flag, and we see it over and over again. And the age of digital, financial services is just unique. I mean, it didn't used to be the case that, overnight you could have thousands of users. It's just a very different situation now. So something to keep in mind.
Yeah, it's funny. I've been thinking about that point a little bit lately, looking at the CIP regulations, which I know we're going to chat on in a second. But like you read them, it's like, oh, these were clearly not written for the digital era when, to your point, thousands of people can be onboarded pretty quickly.
Right.
So makes for fun problems.
Yeah, fun might not be the right word.
Yeah. What originally caused me to want to do this podcast is I know you've been thinking a lot about debanking. It's a big topic at the beginning of the year. It's simmered down a little bit, but it's still in the headlines a bit. I know you've been writing and thinking a lot about it. So break down debanking for me. Where does it historically come from?
Yeah, I have been. I mean, I find it a fascinating topic. I know it puts a lot of pressure on banks, and I think trickle down pressure to the whole financial services industry. I'm kind of fascinated by the fact that debanking is also just kind of a new made up word, like in the last year. I didn't do a fully, scientific survey, but when I looked, I only found one mention or use of the word by the federal government in 2024, and it was actually by the CFPB in a different context. So, obviously it sounds a lot like de-risking, which is a word that has been around for a while. And there's, sort of always been this tension between avoiding risk as required, or, at least some level of reasonable risk, and not cutting out whole segments of the population from having financial services. But in terms of sort of the history of the current debanking push by this administration, it really comes out of the skepticism of something called Operation Choke Point, which was a law enforcement initiative that started back in 2013, which intended to put pressure on banks to reduce access to banking services by certain types of high-risk categories, which included like payment processors, payday lenders, even money transmitters at the time. And so there's a lot of skepticism about that. And over the years, various industries have felt cut out of banking services, including, for instance, crypto, digital assets. And I've been working in that for many years. And I know that that is, in fact, true. It was practically impossible for a good amount of time to get a bank account or operational or other services by banks if you were in the crypto business. But so obviously there have been shifts in the political priorities of the government in this administration. And so we now have the banking executive order. We have new rules by all the federal banking agencies that have removed reputation risk from considerations by banking examiners, and, expectation that that will not be considered by banks. We have an investigation ongoing by the OCC into a number of banks regarding their supposed debanking practices and threats of referrals to the Department of Justice for improper debanking practices. Now, I think there's a lot of legal issues and questions about whether that could ever withstand legal scrutiny, but there's certainly a lot of focus on that. So it raises a number of questions in my mind that we don't have good answers for. Can a bank or a financial institution simply decide who it wants to do business with? And, it's not just crypto, but we see a focus on various other industry sectors, clean energy, diversity and inclusion, various other things that, are the subject of the focus of this administration. But can a bank have preferences on its customer base? And obviously there are constitutional requirements, due process and equal protection concerns and all of that. But, these questions come up. And what's required on a risk analysis for a particular customer? And then, the most difficult part is like, how do you anticipate the political interests of each administration, which may change significantly?
Yeah, it's such an I hadn't thought about this, but it does really strike at the heart, to your point, of what a bank, how banks function in society. Like, are they these private or publicly traded entities that, can compete with each other, make their own decisions, or are they more like a public commodity? Because in a sense, I think you could argue that the current administration's push to, get rid of reputational risk as a factor and other sorts of things that take away some agency from banks to decide who they do customers with kind of makes them look a little bit more like a commodity, which is not something I normally would associate with the view held by the current administration. But it's interesting. I hadn't thought about that.
Yeah, it's really interesting. I mean, it's tough questions for the banks.
Yeah, I know the reputational risk removal is such a fascinating thing to me because it is a powerful tool that can be used overly broadly, but also is a kind of critical release valve for a lot of financial institutions in circumstances where, like, well, maybe there's fraud, but there's no clear smoking gun. It's generally in a high risk. Like, there are sorts of decisions that, sometimes need to rely on reputational risk, and now that's no longer an option. So
right, and just the whiplash, right? Because it used to be that reputation risk was an easy finding by the regulators. Well, you didn't take into account the reputation risk here, and it was very easily, one of the sort of negative findings. And now it's the opposite. So it's challenging.
yeah, this the past, I don't know, 18 months, I keep thinking that compliance officers have probably never had to update their policies as frequently as they have to right now. A lot
Right.
of fast change going on.
For sure.
Related to debanking is the CIP or KYC, the concept. How does KYC change in the era of this pushback on debanking?
Yeah, I mean, another like pet topic of mine, because again, KYC, everybody sort of talks about KYC. Lots of people talk about it and think they know what it is, but really don't, and of course there are people who work in this area and really do, but KYC is another term that doesn't, or acronym that doesn't show up anywhere in any statute or regulation. So it's a broad term that encompasses both sort of customer identification and customer due diligence. And so the due diligence part is where there's the overlap with the debanking issue. And so with the debanking pressure, there is also pressure to do customer due diligence and make risk decisions on a customer by customer basis and to avoid making it on any sort of sector basis. It also includes sort of ongoing and enhanced due diligence, which is its own challenge in a market where customer and financial activity is constantly changing and really evolving at light speed at this point in time. But so really the debanking piece overlaps with the heavier focus on customer due diligence and the need to have very clear decision making around customer, onboarding, offboarding decisions around serving certain categories of customers or not.
Yeah, assessing customer risk, big changing topic right now for fintechs and banks. You wrote a piece in the American Banker arguing that the Trump debanking exec order puts banks in this kind of impossible position where the Bank Secrecy Act requires that they have to assess customer risk, but the exec order tells them not to. So how are you advising fintechs to think about navigating that tension right now?
Yeah, it's tough because banks are figuring this out themselves. So they've got this pressure. At the same time, there's been this very significant opening of the door to a lot of new types of activities, the type of things that would have been called, novel activities under the last administration. But there's also a sense that, they don't know if that open door will be a trap when there's a new administration. But things are moving very fast. There's a lot of exciting development in the world of financial services. Banks want to be a part of that. So, there's a real interesting challenge for them. And that affects, obviously, the fintechs that they're, thinking about getting to know, partner with, using as service providers, et cetera. So I think about it in a couple different ways. I mean, there's this sort of real exciting rush to bring in fintech partners to do all kinds of new things, whether it's crypto activity or other types of new financial services. And it's possible that some of that may distract from some of the core due diligence considerations around basic compliance standards that banks need to meet. And fintechs, just because any business, any highly regulated, complex financial services business that is not that old is going to have a challenge to build out, a full compliance program. It's just not something that pops into existence overnight. And so I think, there's going to be a lot of interesting conversations around, what are the compliance standards that fintechs need to meet? Are they sufficient for banking standards? Do the banks understand it? Is there flexibility that can be applied or not? How do new technologies, which this administration is pushing for incorporating, how do they fit and meet those standards? There are no standards that the government has set out in terms of taking on new higher risk activities that this administration may favor. There's no safe harbors for doing that in the vein of sort of avoiding debanking. So banks are really trying to figure out what they need to do to take on novel fintech customers and also partner with them in a way that they hadn't done previously. And so in terms of, advising fintechs on this, it's really all the basic stuff about that we've already talked about, the documentation, the staffing plan, the technology plan, and sort of building for the future, which is taking advantage of the new opportunities that exist today, not getting bogged down by overly cumbersome practices and policies and all that, but keeping an eye on the fact that there will probably move a little bit more towards center, in another administration, and wanting to be prepared for that.
I love it. Yeah, it's a wild time of change in compliance and risk.
Yeah.
Exciting time to be in the industry. Well, Laurel, thanks so much for coming on. This has been an awesome conversation. You clearly have a lot of great experience and insights. So if folks want to get in touch, where should they go?
Well, thanks. It's really been my pleasure. Yeah, I'm at Jenner& Block in DC, and my profile will give you anything you want to know about me. And I would love to have any conversations that might be helpful on the full 360-degree view of operating in this brave new world.
Awesome. Thanks so much for coming on.
Appreciate it. Thank you.